I will never talk to any police officer under any circumstances, with all due respect, sir. The Fifth Amendment to the United States Constitution provides, no person shall be compelled in any criminal case to be a witness against himself. And this unfortunate amendment has gotten a bad rap in recent times. One of the reasons I decided to give this talk, I recently received a phone call from a former student of mine, a Regent Law School graduate, who may be watching this online. We're putting it on the internet. And he told me, hey, I've been approached by the Internal Revenue Service. They want to ask me a couple of questions. They ask if I'd be willing to. But they say that I'm not a suspect. And I know in my heart I don't think I've done anything wrong in violation of the Internal Revenue Service provisions. Lord have mercy. There's no man on earth, there's no woman in this country who can honestly say with complete confidence, I know I have never violated any provision of the Internal Revenue Code. He said, but they say I'm not a suspect and I know I've done nothing wrong. It's okay if I talk to him? I said, no, you tell them you will not talk to them without immunity. I explained to him why that was true, and he never heard from them again. Okay, why you should never talk to the police. Let me just spell it out for you. Let me make it plain to all of you. These are the top 10 reasons. I shouldn't really lie to you. I don't really have 10. I don't have time for 10, but I've got time for 8, and that'll be close enough. Number 1, and this really ought to be good enough. Contrary to what you laymen instinctively and naturally suppose, it cannot help. There is no way it can help you. Plenty of folks think that it can, and they're always wrong. You cannot talk your way out of getting arrested. Officer Brook, you've interviewed thousands of criminal suspects. Have you ever, how many times in your experience, have you approached someone, asked if you could ask him some questions because prior to the interview you had some evidence pointing to his possible guilt? And because of the extraordinary persuasiveness and eloquence with which he articulated his innocence, you said, oh, sorry, never mind. Bad call, my bad, I won't. And he talked you out of arresting him.
You know the answer to that.
Never. Never. It never happens. What you tell the police, even if it's exculpatory, cannot be used to help you at trial because it's what we call hearsay. Under the rules of evidence, specifically Rule 801D2A, if you want to look it up, everything you tell the police, as the saying goes, can and will be used against you, but it cannot be used for you. From time to time, I've known attorneys who tried to call to the stand a police officer and say, officer, would you tell the jury what my client told you because what my client told him is actually good for my case? If you tried that at trial, the prosecutor will object that it's hearsay, and the judge will agree. The police will not be allowed, at your request, to tell the jury what your client told him, no matter how good it may be for your case. It cannot help. And that ought to be good enough reason. That ought to be reason enough to keep your mouth shut. Number 2, obviously one of the most obvious, if your client is guilty, as many of them are, but even if he's not, even if he's innocent, he may well admit his guilt with no benefit in return. Now, of course, many of you are thinking to yourself, well, what's so wrong about that? I mean, shouldn't guilty people be confessing? Confession's good for the soul. It's good for law enforcement. It's good for the prisons. Yes, sure, all those things are true. And like the rest of you, if I or anyone close to me is ever the victim of some sort of a serious crime, I hope they get the right guy. I hope they convict him. I hope they put him away. We all feel that way. In federal court, 86% of all defendants plead guilty at some point before trial. If your client is guilty and really ought to punish and really ought to have go through some sort of a cleansing act of contrition and fess up and admit his guilt, there'll be plenty of time to do that. They almost always do. No need to rush, no need to tell the police something. Wait and see if perhaps your client can work out some sort of an arrangement where maybe he'll make some sort of compensation to the alleged victim, or maybe he'll be able to get some sort of a discount in his sentence. And he'll be treated fairly then, like everybody else who had the benefit of a good lawyer who said, please do not talk to the police. And don't forget, by the way, even if your client only admits things that the police already knew, you might think, well, what harm can it do? He says he wants to talk to the police. All he wants to do is admit that he was there, but the cops know that he was there. All right, go ahead and tell him. Well, how can it hurt? It might hurt if the police officer becomes transferred to Minnesota, or deceased, or injured, or comatose, or cannot be located by the time of trial. The case will be dismissed if there's no confession. But if your client admits two things, that confession is freely admissible against him, and it can be a basis for getting him convicted all by himself. The Innocence Project of the United States has confirmed that in more than 25% of all the cases where an innocent man was convicted and then later released from prison after he was exonerated by DNA evidence, in more than a quarter of those cases, these innocent people we know to be innocent, made incriminating statements, delivered outright confessions, or pled guilty. How do they do that? He'll tell us all about it, I trust. Here's a couple of famous examples. You can just ask them. You don't have to take my word for it. There on the left was Eddie Joe Lloyd. He was convicted in 1984 of the murder of a 16-year-old girl in Detroit after he wrote to police with suggestions on how to solve various recent crimes. During several interviews, police fed details of the crime to Mr. Lloyd, who was mentally ill, and they lied to him and convinced this mentally ill man that by confessing, he might help them smoke out the real killer. He later signed a confession, gave a tape-recorded statement. The jury deliberated less than 1 hour before convicting him on the basis of this confession. There was no other substantial evidence against him. The judge said, I'd hang you if I could, but the death penalty was not available in Michigan at the time. But after almost 2 decades in prison, he was released after DNA evidence proved that this man was innocent and had falsely confessed to a crime that he did not commit. Number 3, even if your client is innocent and he denies his guilt and almost entirely tells the truth, odds are good he will easily get carried away and tell some little lie or make some little mistake that will hang him. This is human nature. He gets in there, it's a stressful situation. Imagine a perfectly innocent client. The police say he's been guilty of a murder. He's totally innocent as any one of us. So he goes in there and he meets with the police. He says, I don't know what you're talking about. I was nowhere near there. I didn't kill him. I've never killed anybody. I don't have a gun. I've never had a gun. I've never touched a gun in my life. I was nowhere near Virginia Beach that night. That last line was a lie. He went over the top. He was getting carried away. He got into this groove. He started saying all kinds of things, almost all of them true, that he knew would tend to exculpate himself. Then he got carried away and just said one thing that wasn't true, and unfortunately for him, they can prove that it wasn't true. He may be convicted on that basis alone. Even if your client is innocent and only tells the truth and doesn't say anything that is false. Now, already, mind you, we're pretty well nigh into fantasy land. The odds of anybody being able to pull this off are really quite slim, no matter how innocent they may be. But just the same, let's pretend. Let's assume he gives the police nothing but the truth, and he is totally innocent. He will always give the police some information that can be used to help convict him. Always. For example, suppose you tell this to the police. Here's what your client tells to the police in his denial of guilt. I don't know what you were talking about. I didn't kill Jones. I don't know who did. I wasn't anywhere near that place. I don't have a gun. I've never owned a gun in my life. I don't even know how to use a gun. Yeah, sure, I never liked the guy, but who did? I wouldn't kill him. I've never hurt anybody in my life, and I would never do such a thing. Let's suppose every word of that is true. 100% of it is true. What will the jury hear at trial? Officer Brook, was there anything about this, your interrogation, your interview with the suspect, that made you concerned that he might be the right one? Yes, there was. He confessed to me that he never liked the guy. And then the prosecutor will put that up in big letters, and he'll say, ladies and gentlemen of the jury, it's pretty clear that we've got the right guy here. We've proven that he was in Virginia Beach that night. That's opportunity. And remember, Officer Brook admitted that after extended questioning, he was finally able to get the defendant to admit that he never liked the guy. There's your motive. Motive plus opportunity. Wham, bam. The United States Supreme Court, don't take my word for this. In Ohio versus Reiner, the Supreme Court of the United States said, quote, one of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances. Truthful responses of an innocent witness, as well as those of a wrongdoer, may provide the government with incriminating evidence from the speaker's own mouth. See, it's not just some criminal defense attorney telling you this. Even the Supreme Court says I'm right. Ullman versus United States, the Supreme Court said more than 50 years ago, eerily prophetic. They said too many Americans, even those who should be better advised, view this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of crime or commit perjury in claiming the privilege. That's not true, and it never has been. But it gets worse. Can it get worse? It can. Number 5, even if your client is innocent and only tells you the truth and does not tell the police anything incriminating, which, by the way, is almost impossible to pull this off. I mean, imagine talking to the police for 2, 3, 4 hours, and somebody like him can't somehow manage to extract from you something that can be used to help convict you. That'd be extraordinary. I don't think anybody's pulled it off. But even if you could pull it off, there's still a grave chance that his answers can and will be used to crucify you in a court of law if the police, no offense, don't recall his testimony with 100% accuracy. You see, even if your client is innocent and only tells the truth and doesn't tell them anything incriminating, and his statement is videotaped, his answers can be used to crucify him. You might say, wait, how can that happen? I insisted, in my insistence, I called the police and I said, look, if you want to talk to my client, you can talk to him, but only if you videotape the whole thing. I don't want there to be any debate between the two of you over what happened. Okay, we'll videotape the whole thing. If the police don't recall their questions with 100% accuracy, he'll be convicted on that statement alone. For example, suppose a man goes to the police, they say, we're investigating a possible murder, a shooting. And the guy says, quote, I don't know who killed Jones, Officer Brook, with all due respect. It wasn't me. I've never touched or fired a gun in my life. How can that help incriminate this man? How could that possibly be used against this man to help convict him? You would think it's inconceivable. But it's as easy as pie. All the officer has to do is read this statement to the jury, and then the prosecutor says, Officer Brook, was there anything about that statement that confused you or surprised you? Yes, there was, he says, in a moment of sinister, high drama in the courtroom. And what was that? And then Officer Brook turns to the jurors and he says, I never said anything about a shooting. I said we were investigating a murder. He was the one who brought up a gun. Then you turn to your client says, that's not true, that's not true. I remember he was the one, or one of the cops, I was with them for 3 hours, one of them in the car said something about, they said they had a witness that I was the shooter. Okay, I'll put you on the stand. And then your client testifies, no, they did tell me shooting. They mentioned it before I said anything about a gun. They brought it up first. And then the police said, that's not true. And now what, it's your word against theirs? For what? You're gambling with your client's life. And police officers can very easily make a mistake like that. Police make mistakes, innocently, inadvertently, unintentionally. Now, here's the most surprising of all. I've saved the most surprising one for last. Let's suppose you've got the following scenario. Your client's thinking about talking to the police. He acts like he says, I've got nothing to hide. They think that I killed somebody in Virginia Beach last night. Well, this is what your client tells you in confidence. I don't know who robbed that store. It wasn't me. In fact, I've got a pretty good alibi. I wasn't even in Virginia Beach that night, last night. I was 4 hours away visiting my mother in the Outer Banks. Unfortunately, no, I did not pay for gas with a credit card. I used cash, and so I've got no witnesses that can prove I was there except my word, and of course, Mama, for what that's worth, which is nothing. So your client says, so the police want to talk to me, and I want to seem cooperative, so what I'll do is I'll tell them that I was in the Outer Banks last night. Now, there's nothing on its face incriminating about any of that. Let's assume, by the way, that you believe with all your doubt. You've given your client a polygraph exam. You've known him for years. You've been going to the same Bible study for 30 years. You know beyond a shadow of a doubt that he's telling you the truth. And he's not admitting anything. He's not admitting motive. He's not admitting opportunity. He's not admitting that he was there. How on earth could this come back to haunt us? How on earth could this come back to be used against us? Be honest. Raise your hand if you really think the answer to that question is, I can't see how it could possibly be used against me. You're afraid I'll call on you, right? I won't call on you. Well, you're wrong. You're dead wrong. You're always wrong. Everything you say, every time you talk to the police, you will regret it. You see, the problem is, here it is. This is the last point. I think it's almost, even if your client is innocent and only tells the truth and doesn't tell the police anything incriminating, and the entire interview, questions and answers are videotaped, even his truthful answers can be helped to crucify even an innocent man. If the police, through no fault of theirs, end up in the possession of any evidence, even mistaken and unreliable evidence, that anything your client told them was false, even if in fact it was true. Again, going back to this example from a moment ago. Let's suppose I go ahead and I meet with the police. I think I got nothing to hide. I tell them I was in the Outer Banks last night, officer. How can that be used to convict me? By itself, it cannot. It cannot help at all by itself. But what if I later find out, to my horror, after I put my cards on the table, that they've got a witness, a girl that I went to high school with, an unimpeachable witness. We've never been enemies. She'd have no reason to lie. She swears she thinks she saw me in Virginia Beach last night, a couple of blocks away from that store, about an hour before it was robbed. Now, her testimony by itself isn't going to help the prosecutor. Hell, if she's all they've got, I'll get this case thrown out before trial. But if, like an idiot, I talked to the police and I told them the truth, I told them I was in the Outer Banks, and now, lo and behold, tragically, it turns out they've got a witness, a false, mistaken, confused, but sincere and credible witness who could testify that I was here in Virginia Beach. Now they're likely to get a conviction. Because what they'll do, I've just turned this cop and this woman into the government's star witnesses. They'll put Officer Brook on to testify about how my client lied to him about being in the Outer Banks, and then they'll put on this girl who otherwise would have not even helped with their case at all, who will testify, no, that's not true. That was a lie. I saw Mr. Duane's client here in Virginia an hour before the robbery, not so far from the store. By herself, she would not have helped the government in any significant way. But what I have just done, you see, is given them the other part of the puzzle, and now I'm doomed.